I'd like to reconvene the Lane County Board of Commissioners for this Tuesday, July 26th, for our afternoon session. We have 3 items and an executive session to work through. So the first one is under County Administration, item 14. It's the second reading and public hearing for Ordinance 16-03 in the matter of amending Lane Code Chapter 4 to adopt a local tax on marijuana sales in unincorporated Lane County of 3%, if approved by the Lane County voters in November 2016. We have with us Alex Schuyler, our Intergovernmental Relations Manager, and our legal counsel, Andy Clark. Good afternoon. Guess we just want to do one at a time, or?
It's your
I'm
pleasure.
going to read the second one in, deal with them both at the same time.
I think you may as well. Yeah, the
Okay.
discussion will probably cross over both items.
All right, so then the second item, which is nearly identical, would be the second reading and public hearing for Ordinance 16-04 in the matter of amending Lane Code Chapter 4 to adopt a local tax on marijuana sales in unincorporated Lane County of 3%, if approved by the Lane County voters in November 2016. Okay.
Okay, thank you, Chair Stewart and board members. Alex Schuyler, your Intergovernmental Relations Manager. So this is your second reading on 2 ordinances, essentially identical. Both pertain to the establishment of a local tax on marijuana items. This is ultimately a result of the voters' passage of ballot measure 91 that legalized recreational marijuana sale, growing, and use in Oregon. That was a statutory measure that was passed in 2014, and both in the 2015 and 2016 sessions of the legislature, there were a number of tweaks to that law, including House Bill 3400, which established, among other things, that local governments could tax the retail sale of marijuana items at a rate not to exceed 3% by passing an ordinance and then referring that ordinance to the voters of the local government's jurisdiction at the general election. So there are a number of cities and counties across Oregon that are really dealing with a very similar issue right now. The way the law reads is that each city must pass their own ordinance and then refer that to the voters. Each county must pass their own ordinance and refer that to the voters of the unincorporated portion of the county. The other notable thing about the law is that the tax only pertains to those retailers that are located in those respective jurisdictions. So we don't have very many marijuana retailers located in unincorporated Lane County. We do have some. The other thing that I think we touched on when I was last here was that we are in a period of transition with respect to the sale of recreational marijuana. The so-called Early Start program, where medical marijuana dispensaries and recreational marijuana retailers were able to be co-located on the one footprint, will end on December 31st, and after that, those two have to be separated, with the recreational marijuana retailers getting a license to sell from OLCC. So with respect to the actual ordinances, the difference, each ordinance starts with a title, goes into definitions. Those are the same. There's a policy that says that you impose a tax of 3%. There is a statement about revenue collection. Staff would recommend that the county enter into an agreement with the Department of Revenue in order to have the tax collected, because there is a 17% tax that Department of Revenue currently collects, and it would just probably be easier to let them collect the local tax on behalf of us. And then the only difference it gets into between the 2 ordinances is the use of proceeds. So in 1603, the use of proceeds is what we call restricted. In other words, there was a request to staff to bring forward this ordinance that would earmark those dollars into specific purposes. 1604 is what we call non-restricted, and the only guidance there is that it would be placed into use for general government purposes. And so those are the differences. And if you recall, in your first reading of the restricted version, 1603, you made a few changes to that based on sort of thinking about it since that earlier presentation. And then I included a memo on 1603 that even speaks to further changes if you want to make them to 1603 that we think will be good language with respect to the use of proceeds. Administrator Mokorheisky this morning gave you a piece of information about his meeting with regional managers. None of the other jurisdictions that are putting this to the voters have decided to go the restricted route. And in my review of a couple of other county ordinances, I didn't see the restricted route being taken as well. And I think the experience of now having potentially going to a third reading with this language points to some of the difficulties of using a restricted tool, if you will, in that we've got to make sure that language is right because it is being an ordinance that's referred to the voters. And this is the whole realm of recreational marijuana retailing, I think, is really still in flux. My understanding is we will continue to see in the 2017 session even some new thinking about how marijuana is bought and sold and produced in Oregon. So we're going to continue to see this law evolve and probably eventually even see some federal regulations come down in the future, depending on how other states adopt or not, or don't adopt recreational marijuana laws. So I think that's what I can tell you. If you have any questions, I'm happy to entertain them.
Okay. Do we have any questions before I open the public hearing? Okay, seeing none, I'd like to open the public hearing on ordinance 1603 and 1604. Is there anyone here that'd like to speak?
Will somebody open the door, please?
Door locked? All right, seeing that there are none, close the public hearing. And look to the board for discussion and potential direction. Commissioner Farr?
Thank you. The only thing I'd like to say is that we did have a discussion. Mr. Kyler was with me at the Mental Health Advisory Public Local Drug and Alcohol Policy Committee meeting, and who give us great advice and have been for years on issues surrounding behavioral health. And they would like to see a dedication as much as possible to specifically to behavioral health and to the broad spectrum of behavioral health, which would include substance abuse treatment, and prevention. That being said, we had the discussion, and I told them that I would come back and support the second ordinance without the percentages in it. That is, second ordinance which does identify four areas of potential use of the funds without identifying percentages. And the reason they supported that is that because they felt, and the discussion was, that potentially if behavioral health issues rose to the top or in any one given revenue period, behavioral health issues needed particular attention, then more than the 33% or more than the 25% could go to behavioral health. That being said, I told them that I'm not ill opposed to no restriction on that. So I'll just wait for the discussion among the board and look forward to see how we go forward.
And Board, Commissioner Farr is speaking directly to the changes that were in the memo that is the new material in today's item. And so that's really a proposed change A. That's where, in fact, the financial planning manager after our meeting at the first reading said, you know, that 25% allocation to each service is potentially problematic. Why don't you get rid of the 25% but keep listing the services? And that was the discussion around item A.
Thank you, Mr. Kyler.
Okay. Commissioner Bozevich?
Thank you. I just noticed somebody that walked in that may have been looking for the hearing.
Okay.
That
All right,
Maybe we
so
can
what I
back
can
up.
do is reopen the public hearing at this time, and we could just ask the gentleman to come forward and state his name and good afternoon. If you don't mind, you can come up to the podium and state your name and general area of residence, and then we'll allow you to speak to the board.
Yes, I'm Dan Kuzer. It's Dan, it's Kuzer's in Boozer Lake, but not a potato drink. But I'm the founder and executive director of the Eugene event called the Emerald Empire Hemp Fest. The city of Eugene denied us the use of the park this year because the accusation was that I allowed pot use at the park. So it strikes me as odd, anytime a government starts trying to tax cannabis. Let me give you a little bit history. In 1937, marijuana was made illegal. Ever since 1937, marijuana users have been persecuted. They've been fined. They've been jailed. They lost their family. They lost their possessions. And that's continued since 1937. And it still continues even now we have so-called legalization, but it's better than it was. The point is, we've been taxed with marijuana since 1937. It's time to stop, not start. So, majority of you on the board, I know, are anti-marijuana. I know, we all know that. So then you don't have a problem taxing it. So how can you speak about taxing? I mean, anyway, I guess that's what I just got to say. It's wrong, 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 but that's nothing new for Lane County. Thank you. Any questions?
Thank you. All right. Thanks for your testimony. Okay. So at this point, with no further public testimony, again, close the public hearing and continue our conversation. Commissioner Bozovich, were you in the queue or?
Yeah, yes, please. Okay. So I would like to advocate for us moving forward with ordinance 1604 and not designating where or restricting where any funds collected could be spent at this time. I think as demonstrated by the concerns over language about the restrictions and all that stuff, we're going to end up with multiple readings trying to get that just right. And we do have a budget committee that has a very extensive process with public input about where general funds go. And I think that's probably the place to do that, particularly that we don't really have any idea how much revenue this will generate, if any, in Lane County, to pre-designate it and maybe even put hopes up for programs that, at this time, we just have no idea what we're looking at in the way of revenue. So I would advocate that maybe we just let 1603 die at this time and move 1604 ahead to the ballot.
Okay. Commissioner Lycan?
Thank you, Mr. Chair. I would concur. I think based on the fact that we don't really know what this will generate, and like I think Commissioner Bozovich stated it correctly, if any, we don't know that right now. And so I think adding a percentage would, at this point in time, would not make a lot of sense. So I would agree, and I would advocate moving 1604 forward and to be referred to the voters for November election at this point in time. Thanks.
Other comments? Mr. Kyler?
Thank you, Mr. Chair. The other thing that did come up as a contemplation, you'll see a future order actually referring the ordinance that you select to the voters. And there is a tool there. There will be an order that has a number of whereases, and now therefore is to send that to the voters. And you may choose, if you like, to insert some language into one of the whereases that there was another ordinance that contemplated this, or that the board discussed earmarking these dollars. I mean, that's a tool that the board could use to sort of to send in some intent forward as well with respect to how the dollars are used. I think it's certainly much less binding, but it is a way to use that future order to reflect this conversation.
Okay. Commissioner Farr?
Thank you, and thank you, Mr. Keller. I was going to make that suggestion after the motion was made, that we do have that latitude to use whereases, and if we wanted to use the 4 bullet points that originally were percentages of allocation, we could formulate 4 whereases surrounding those 4 bullet points: public safety, public health services, mental health services, and zoning regulation are the 4 bullet points. Not suggesting that at this point in time, but thank you for bringing that up. We do have the latitude to state some form of intention, binding or non-binding though it may be. Also, I'll apologize, I misspoke a little bit earlier. I said ill-opposed. If I were ill-opposed, then I'm not ill-opposed, I'm not opposed. Thank you.
Okay. All right. Well, thank you. With ordinance number 16-03, I was concerned with the actual percentages, a little less concerned about just having 4 areas where the money gets spent, but I do think after the trials or the efforts that we've made in other areas around allocating funds, whether it's our jail levy and the language used or the youth services, that probably not finding ourselves or future boards down the road challenged by some language that maybe weren't as clear as it could have been. I think that I could find myself supporting 1604 because of that. I would like to say, and I don't know if it should be included in the whereas, but I think typically and most of the time when we allocate our resources, we allocate it to be used on areas that are impacted by where the resource comes from. And so, whether it's money that we receive from the state for alcohol tax, it generally goes to those services, or whether it's, Short Mountain or our waste department, those resources go there. So I don't think that it would be a stretch to assume that future boards and budget committees, when they're making recommendations, or even our staff would, if you recognize that there's a need in a certain area, that would be where the recommended resources for that year be spent. So with that, I could find myself supporting 1604. Other comments? Hearing none, Commissioner Bozevich.
So I'd like to move approval of ordinance 1604 in the matter of amending Lane Code Chapter 4 to adopt a local tax on marijuana sales in unincorporated Lane County of 3% if approved by the Lane County voters in November 2016.
Second.
Okay. So I have a motion and a second. We also had a discussion about adding something to the whereas. Would that need to take place in the motion, or is that something that we can discuss after this?
No, Mr. Keller was actually referring to the future board order rather than this ordinance, which would have the effect of referring it to the ballot if this is approved.
Okay. I thought I saw a
Come later.
future board order.
Mr.
Okay.
Chair, we haven't scheduled that necessarily. We were waiting to see what the outcome for today was. So it'll either be one of your next 2 meetings, I believe, before the one of your next 3 meetings before the deadline to actually refer this to the voters.
Okay. All right. Commissioner Farr?
And Mr. Keller, at which point, or Mr. Clark, at which point would we discuss the whereases? Is that something that staff would put forward based upon perhaps language we've already established? Or does the board need to actually have a discussion on that?
It could happen any time, really. The board, you can discuss it now if you want, or when the matter is on the agenda.
But since it's not an ordinance, we could change it essentially on the fly and pass it in the same meeting we discuss it.
Right, and you've got as we said, an order that would refer this to the electors if the ordinance is approved today. In that order, there are two sections generally, the whereas section and the ordered section. The whereas really serves as sort of history and background for the order that follows. Putting information there is really just a signal of what the board currently contemplates as important areas where this money may be spent, but doesn't have any binding effect at all. You could, in theory, put restrictions in the ordered section of that order, which would have almost a similar effect. It's somewhat more binding, but realizing that this board, when it adopts a budget, does it by order, that order would essentially override the one adopted when referred to the ballot. So it's really a signal of sort of present where the board's brains are collectively on the issue of where the money ought to be spent is kind of what it would serve as.
Thank you for that clarification, Mr. Chair. It sounds like sounds as though the order itself to put this on the ballot will come forward at maybe our next meeting or the meeting after. At which point the whereases would have been tagged along. And as an aside from the motion, Mr. Chair, I might suggest that you take the 4 bullet points that are listed in this draft that you provided as Mr. Kyler and just form 4 whereases around those 4 bullet points that we've already discussed.
Other comments? Okay. So with that, Mr. Mokahysky, would you call the roll?
Commissioner Sorensen?
Aye.
Commissioner Farr?
Aye.
Commissioner Lycan?
Aye.
Commissioner Bozievich?
Aye.
Commissioner Stewart?
Aye. Okay, thank you.
Passes 5-0.
All right. So with that, any further direction or comments on this specific item at this point? Mr. Clark?
I think, given Commissioner Farr's statements, if the board wants to give direction to staff about inserting whereases along the lines of those 4 items, now would be an appropriate time to do that.
Okay. Commissioner Bozievich?
I'll just give my direction, my consent to the direction to add those 4 bullet points into the whereases. So there is at least some history in the whereases of the legislative intent of this board was to designate that money to those particular areas. We just didn't want to get hung up on exact language and all that. It gives us a little bit more flexibility to the budget committee. Should we only get, a couple $1,000s out of the tax, we're not splitting that up 25, 25, 25. We might just decide to throw it all in one of those 4 areas. And a secondary question, do you need any direction today relative to forming a committee to do language for the ballot language and other issues revolving around that?
Chairman Stewart and Commissioner Bozievich, if you recall, back in when you asked staff to create that first reading, incorporated in that motion was to ask staff to find a explanatory statement writing committee. So we are underway with that, and we'll bring that order to you in one of the next several meetings as well.
Excellent, thank you.
Yep.
I think agenda setting, we actually tentatively have that item, and I think the companion, which we just discussed for our next meeting. Okay, so we have a couple. I certainly would support including that the information in the whereas. Mr. Lycan?
Thank you, Mr. Chair. So I'm assuming there's the head nods from the board on that, because I personally am opposed to it. I think it's premature right now. I'd rather we did and wait until we actually see what kind of revenue is going to come in and then make that decision later on. So, but I think you got your 3 head nods, but if it did come back to the board for a vote, I'm going to vote no. And so that's just where I'm at right now. I just think it's premature.
Okay.
Thanks.
All right. Commissioner Sorensen, you got any comments? Okay. All right, thank you. So then we will go back to the item that we moved from this morning, which is the item 8C. It's a report on the Legislative Committee recommendations. And once again, we have Mr. Kyler, our Governmental Relations Manager, for this item.
Thank you, Mr. Chair. So in your packet of materials, you have a memo from me on this, on the report back from the Legislative Committee. And essentially what I tried to do with that memo was to break it into 3 distinct categories of things that we actually discussed at Legislative Committee. One was follow-on ordinances that would be allowable as a result of action that the 2016 legislature took. The second item was to establish 2 new legislative priorities, and the third is to respond to correspondence that the board received from the Mental Health Committee a while ago, I believe in the fall, actually the fall of last year. So if it's okay with you, I'll just go through these one at a time. The 2 ordinances that the Legislative Committee are recommending that you move forward. One was the result of Senate Bill 1513 in the 2016 session. The second was the result of the passage of Senate Bill 1565 from the 2016 session. So first one is Senate Bill 1513, and what this allows local government to create a special tax exemption for the surviving spouse of a fallen public safety officer. This is a measure that is got some flexibility to it. It allows the county to do that tax exemption either by resolution or by ordinance, is the way the bill reads. And Lane County doesn't really have a strict resolution. We have a resolution in order format. And I think Legislative Committee felt like it was a worthy topic, worthy enough to actually put into Lane Code, so that it just lives there. And in the unfortunate event that we do have an occurrence where a member of our public safety community is lost in action, so to speak, then you've got that tool available to you. It's just right on the books. So we think this is a fairly easy ordinance to construct. It will allow that surviving spouse to enjoy that tax exemption as long as they do not remarry. And it does, I believe it has a cap of up to $250,000 of real property value. So I think it was a good bill in the session, and there'd be a little bit of work to go through several readings of this, but the Legislative Committee does recommend that you do direct staff to develop such an ordinance.
Okay.
Second one is the implement.
Mr. Kyler?
One
Commissioner Lycan?
So on this particular, Alex, I just want to say thank you to you and Sarah on this. And we've been dialoguing about the Kilcullens are personal friends. And so talking to both John and Christie's has called me about this. And so just so you know and the board knows, if we move forward on this, she will be thrilled. And so she personally put out a personal plea to me and on this particular. So I was glad to see the Legislative Committee come back with this, and here we are today. But I just wanted to make note of that. And but I'm to you and Alex, to you and Sarah, I want to say thank you for at least I could provide her an answer where we were and when it was going to come forward back to the board. And so I'll once we. If the board takes formal action, then I'll be more than happy to notify her and let her know. So I just want to make note of that.
And I guess
Appreciate
I should mention to the board that there is a way, this ordinance could be written in order to provide as much as possible. We could write that ordinance to take effect of the day of effect of the bill. And so there would actually be a benefit for about half of this tax year.
Okay. Thank you.
All right. The second one is Senate Bill 1565. This is not unlike a rural enterprise zone. It is a tax exemption for industrial development within rural areas of the county. It's not limited necessarily to unincorporated Lane County, but so I think cities smaller than 40,000 individuals can also take advantage of this. So This one does provide for a tax exemption for 3 out of 5 years for investments that a company makes inside a rural area for costs that exceed 1 million but do not exceed 25 million. There is a requirement that at least 75% of the taxing jurisdictions in the area approve the ordinance. So there will be a little bit of work with this one to ensure that we've got all the language right. It's a little bit more complicated, and to, as it marches through the process, that there's a formal way to establish for the board that those taxing districts that represent the 75% of the entire revenue are okay with it. They have to provide approval for the ordinance to move forward. I think there was some interest in this bill in particular during the 2016 session, and sort of thinking about the work that the board has already undertaken with respect to Goshen, and if this might be a tool with respect to Goshen. I happened to attend a meeting with the RAIN network the other day on Friday, and this might be a tool for companies, for example, coming out of RAIN. There's just a number of different companies that may take advantage of this kind of thing. We did, at Legislative Committee, get a sort of range of impact from the assessor, and so it really does depend on what size business that would be looking at taking advantage of such an exemption, and I think I have some information about that. Yeah, so for a smaller use, say $1 million investment, the total exempted for a year would be what the assessor thought was about just under $8,000. If it were a $25,000 investment, the total amount exempted for a year would be just under $200,000.
That's 25 million, right?
25 million, I'm sorry if I said, yeah, 25 million. And that's, again, that's for, this exemption gets to last for 3 out of a 5-year window. So my understanding is that depending on how we craft the ordinance, that may not occur could occur in the first 3 years. It could be spread out over 5 years. I mean, it just depends on how, I think we write the ordinance and how the company wants to take advantage of that.
Okay. Commissioner Lykin.
Thank you, Mr. Chair. So, Alex, when you say rural Lane County, this is unincorporated, is that correct? So like, for instance, this would not be a fit within the city limits of Lowell. This would have to be outside of like because I view Lowell as being rural Lane County, but it's an incorporated city. So is that how this works?
Chairman Stewart and Commissioner Lykin, my understanding in that case that the city of Lowell would need to pass its own ordinance making that tax exemption.
Yeah. So,
But the city of Lowell, being under 40,000 residents, would have the authority to write such an ordinance under Senate Bill 1565.
yeah, okay. Thank you.
Commissioner Bozievich.
So this, actually, the 25 million cutoff kind of fits nicely with another program and one that almost got utilized when we had a certain applesauce factory looking at Coburg, and that's the strategic investment program the state offers, which picks up at 25 million and above in capital investment. I think this is a good tool for us to utilize. Of course, it'll be a little bit complicated, and I may not necessarily want to limit our thinking to Goshen as I look at some rural industrial properties along the Siuslaw River in my district and in other spots where there's former mills that are designated rural industrial properties that are sitting vacant, which may have the ability to be future employers and at some time if they're change in use or something. It may take some kind of strategic program to get somebody to invest the money to repurpose those facilities to be employment centers. So I wouldn't want to just limit ourselves to looking at Goshen only, but that may be the starting point for this, because it is a pretty complex program under the Senate bill, where we've got to do quite a bit of description in there, so maybe that's the first place to go. But I would also want to look at some of those abandoned mill sites as being able to be part of this program.
Okay, thanks. Any other comments on a specific item? So I'm kind of headed to where we'll take action in the end, or do we want to deal with these? We've talked about the two ordinances. Do we want to go ahead and consider direction to staff on those two items at this point?
Sure. Do you want those in individual motions, or?
I think that would probably be best.
So, Mr. Chair,
Commissioner Bozovich.
so I would move that we direct staff to implement Senate Bill 1513, the creation of a special tax exemption for the surviving spouse of a fallen public safety officer.
Second.
Okay, further discussion on the motion? Okay, all in favor?
Aye.
Any opposed? Passed unanimous. Thank you. So we got, the next item would be Senate Bill 1565. Commissioner Bozovich.
Mr. Chair, I move that we direct staff to develop implementation for Senate Bill 1565, creation of special tax exemption for industrial development within rural areas of Lane County.
Second.
We have a motion and a second. Any further discussion? All in favor?
Aye.
Any opposed? Pass unanimous. Okay, so then we're on to the new legislative priorities.
Certainly. All right, thank you. So the Legislative Committee, as you recall, we have a number of legislative priorities. Practice has been that if we have not been successful at the legislature with those previous priorities, typically we leave them on the list, so we sort of have a growing list of specific legislative priorities. And just to be clear, when you place a item onto this so-called legislative priorities list, then essentially you're giving the staff authority to go try to get a bill written, introduced, we lobby for it, and we give it our best shot at getting it through that process in Salem. The Legislative Committee had discussed two new legislative priorities at their May meeting. The first one is, I've titled it Recreational Immunity. This is actually our second time dealing with this issue. We were, I think in 2011 or 2013 session, passed recreational immunity for the first time, essentially saying that if a public agency has a recreational property that in order to enjoy, somebody must or may cross private land to get there, that landowner is immune from liability if somebody were to somehow injure themselves on that property. What this new priority is all about is actually a court case that came out of the city of Portland, whereby two employees had, I believe, been working on a sprinkler or some sort of underground irrigation, had buttoned it up for the evening. The project, it wasn't completed, but they taped it off, and a runner who apparently was, I believe, legally blind, stepped into the hole that was left. And the city, while was not named in the suit, instead the actual employees of the city of Portland were named in the suit and were established as liable as individuals rather than being employees of the organization. So what this new effort afoot is to try to rectify that situation to ensure that individual employees may not be named in such a suit. And this case has really thrown a sort of a chill over parks departments throughout Oregon. So both the League of Oregon Cities and the Association of Oregon Counties are very interested in this, in getting this this situation rectified. This would be the kind of priority where I probably won't be the lead person on it. We will leave that to the association or to the League of Oregon Cities, and we will just chime in when necessary. So I'll make sure to track it and to keep tabs on it. May provide some testimony, but I wouldn't necessarily be the lead instigator or lobbyist on this particular effort. Okay. Take questions on that if you have them at this point.
All right. Not seeing any.
So the second priority was something that we discussed at Legislative Committee. It has to do with, we were successful in 2016 in getting the authority to have the state of Oregon issue a bond that provides us with dollars for our courthouse improvement project. That, as I think you know, is a relatively recent creation of statute to allow that to happen. The Oregon Courthouse Capital, the Oregon Construction, the Oregon Courthouse Capital Construction and Improvement Fund was established in 2013. And so the statutes are still fairly new. The statute says that a project may benefit from 50% funding from the state of Oregon if they co-locate a state office, and otherwise the funding available from the state of Oregon is 25%. It's been my observation that there is no definition of co-location, and so questions about if an agency wanted to co-locate with another local agency, for example, there's been discussions with the city of Eugene about potentially even their Muni Court co-locating in a future courthouse. That, while it seems to be good public policy, but under the statute right now would not qualify for a co-location benefit. And it just seems like there's a number of things that we would want to pay attention to with respect to this particular set of statutes as these projects evolve. You'll note in the packet that we did have a conversation at Legislative Committee, somewhat nervous about actually having a bill necessarily relating to co-location, for example, in the 2017 session, because this could be used in other ways as well. But ultimately, I think the committee thought that it was a good idea to at least have it as a priority and sort of leave it to staff discretion about whether to try to get something introduced or not. There may be some ways to do some more narrow uses of a relating to clause to avoid some of the pitfalls that we felt might otherwise occur.
Okay. Questions, Mr. Kyler? So we have the two legislative priorities that were just discussed. Do we want to take board action to add those to the legislative priorities?
Sure. Do you need can one motion include both?
I believe so. We can try.
So I would move that we add the two new legislative priorities on recreational immunity and courthouse bonding and co-location to our legislative priorities.
Second.
Further discussion? Seeing none, all in favor?
Aye.
Opposed? Passed unanimous. So then we have correspondence to the Mental Health Advisory Committee.
Correct. Okay, so this item, I'm sorry, I guess I said that you'd gotten correspondence in fall of last year. It actually came in the spring of this year, March 21st, 2016. The Legislative Committee received a memo from the Mental Health Advisory Committee and the local Alcohol and Drug Planning Committee regarding what in Oregon and actually nationally is known as the Employment First Initiative. There was Employment First is a federal policy whereby folks with developmental disabilities are ensured the ability to integrate into the workforce. In practice, there's been a number of sheltered workshops that have been created, and not every sheltered workplace in the U.S. has turned out to be a great thing. I'm not aware of issues with sheltered workshops in Oregon in particular. Well, there may be some, but there was a lawsuit that then had basically the court ordered that sheltered workshops be adjusted across the United States. The way that occurred in Oregon was through an executive order signed by then Governor Kitzhaber. And actually, I guess this was as a result of a lawsuit in Oregon at a sheltered workshop in Oregon. So this executive order was signed by Governor Kitzhaber, and essentially, it basically suggested that sheltered workshops would have to be phased out, and that there would no longer be that opportunity. There was concern, I think, on the part of the Mental Health Advisory Committee that went too far. And so their request of the legislative committee was to try to rectify this situation both at the state and federal levels. And our response at legislative committee was to suggest that we would insert language into our legislative principles document and as part of the federal agenda within the United Front rubric. And we came up with specific language that reads, support legislative efforts to ensure that individuals with intellectual and developmental disabilities are integrated into community life while ensuring robust opportunities and individual choice regarding community involvement, employment, and other aspects of positive quality of life elements. So in other words, there were a number of folks who were employed in sheltered workshops who actually really liked their jobs, and this was just a way to try to gain some flexibility back with respect to having some choice where people want to be employed.
Questions? Comments? Commissioner Bozievich?
So first, I just want to express my support for us looking into this. My stepbrother, Bob, is a developmentally disabled person, very high functioning though, so he was able to integrate in the workforce. I've got a close friend whose son is very low functioning in a lot of ways. He's both wheelchair bound and blind, although mentally fairly acute. He still needs direct assistance, and integrating into a workplace is not as simple for that Bob. They're both Bobs, by the way. And so, it's not a one-size-fits-all. And unfortunately, this executive order kind of said one-size-fits-all and didn't take into account that there are some folks that are better served in a sheltered workshop, a well-run sheltered workshop. And, if you speak with Jan Aho at Pearl Buck, this has really impacted their programs and their ability to even take anybody new into their program. In particular, it's difficult for those developmentally disabled that are turning 18 and getting out of the school systems and some of their programs there, and not having, even the training maybe to go directly into an integrated workplace, and they're just left adrift in our system right now. And Pearl Buck's not able to take any new people into their system. They can keep, right now they're allowed to keep some of the folks that are already in. You talk to the clients, you talk to the folks, the developmentally disabled, and there's some of them that really like the fact that they can come to that sheltered workshop. And I think one of the greatest comments I heard is, when I'm here at Pearl Buck, I'm free to be me. They don't have to worry about, loud outbursts or some of the what would be considered disruptive behavior in a integrated workplace. It's accepted there at Pearl Buck, and they can be themselves and not worry and not have that stress, and it can be considerable stress to a developmentally disabled person to have to constantly watch their behavior in an integrated workplace versus, I can kind of be myself and let those behaviors out in a sheltered workplace. So I really support us taking this issue on both at the state level and federal level. And I'm wondering if we need a motion to add this to our legislative priorities as a new priority. Would that be?
Chairman Stewart and Commissioner Bozovich, if you recall, we actually have a principles document, and so the priorities have to do with specific issues. The principles is one that's a little bit broader, and I think this one probably fits in that it'll maintain as a principle, and we can continue to work it as we see opportune.
Oh, great. Then I'll support staff continuing to work on this.
Okay. Head nods, or Commissioner Farr?
I just wanted to state that that was an MHAC meeting that I was not present at, so I had no part in that discussion, but I do support moving forward with this. And I had a chance to visit Pearl Buck a number of times. In a past life, I was a finalist for the executive director position there. At the time, they appointed Jan Aho ahead of me, and they made the right decision. I'd have made that decision in their place at that time, too. So I've had a chance to see how that workshop works, and I agree with the statement that Commissioner Bozovich has said, so I have my head nod to move over this.
Okay. So it looks like you got the support of all the commissioners to add that to the principles document. So, Mr. Kyler, does that conclude the legislative?
That concludes. Until next time.
All right. Thank you. So with that, I believe that we went back and took care of this morning's business that was deferred to this afternoon and completed this afternoon's business. So with that, I would look to the administrator for review of assignments.
Mr. Chair, we will, on item 8B, the update that we talked about related to the courthouse, city hall, and farmers market, obviously we'll begin work to implement the board's direction on that front. And we have a meeting, I believe, tentatively scheduled with city staff first thing tomorrow morning to do that. There was then, we did receive 3 head nods for staff to write a letter of support for the Frank Moore Steelhead Reserve, and so we will do that and then work with the agenda team on when and where that should be placed on the agenda. I think that's all.
Okay.
Is anything?
I get that recalls, I believe, what we did this morning or today. Okay. So with that, we do have an executive session. Is there any other business before I read this into executive session? We move upstairs. Okay. So with that, the Board of County Commissioners will meet in executive session to conduct deliberations with persons designated by the governing body to negotiate real property transactions. Actually, and to consult with the council concerning the legal rights and duties of a public body with regard to current litigation or litigation likely to be filed. This executive session is held pursuant to ORS 192.660 subsection 2E and H, which allows the Board of Commissioners to meet in executive session for the purposes listed above. Representatives of the news media and designated staff shall be allowed to attend the executive session. All other members of the audience are asked to leave the room. Representatives of the news media are specifically directed not to report on any of the deliberations during the executive session, except to state the general subject of the session as previously announced. No decision will be made in executive session, and we do reserve the right to come back into public session should the need arise. If we don't, at the conclusion of the executive session, the Board of Commissioners will adjourn. There is a Housing and Community Services Agency meeting tomorrow, July 27th, which will be up in the Commissioners' Conference Room. So with that, we will move upstairs for our executive session.